Thank you very much. Thank you. Thank you for that warm introduction. There's a bit of feedback here, so I'm hoping that someone might be able to help with that. I'd first like to acknowledge the Gadigal people of the Eora Nation. That acknowledgement that all of you will have heard many, many times wraps up in a single sentence 250 years of Australian history. The tragic irony behind that acknowledgement is that we do know and we do honour the fact that we're meeting on Gadigal land, but it is no longer the Gadigal people who occupy this land. I was thinking about that fact, that tragic irony, because in a few months' time, we will celebrate the fact that it is 35 years since Eddie Mabo started his long journey towards Aboriginal land rights in Australia. Eddie Mabo, of course, was the flag bearer to obtain land rights over first his own traditional lands, the lands of the Meriam people in the Torres Strait Islands. Just 3 years after he began that journey, in 1985, the Bjelke-Petersen Queensland government passed legislation that would extinguish every claim, right and interest in that land going back to the 1860s. And it said that it would extinguish every single right, claim and interest, whatever. I just want to pause briefly on the word whatever, because it wasn't really needed, that word whatever. But when a lawyer uses the word whatever, it's a little bit like when a 15 or 16-year-old uses the word whatever. It's basically saying, keep the hell out. So with the stroke of the governor's pen, that legislation would have retrospectively extinguished all possibility of land rights in Australia. It would have brought to a screeching halt the possibility of having Aboriginal and Torres Strait Islander land rights in Australia. And the thing is, it very nearly worked. But in 1988, the High Court, in a case called Mabo No1, and it's not the Mabo case that you're thinking of, said something really important. It said that this legislation, this Queensland legislation, is inconsistent with the Federal Racial Discrimination Act, and they should not be allowed to do this. And that was a really important step along the way before the more famous Mabo case in 1992. And in that case, probably the most famous High Court decision in Australia's history, the court said something really profound. It said, we have been living with a fiction in Australia that when the English arrived here, the land was effectively uninhabited, that the English could do whatever it wanted with the land, and that was that. And the High Court said we can no longer live with that fiction, and instead introduced what's known as native title. There's a really poignant element to this, though. Less than 6 months before the High Court reached that decision, Eddie Mabo died. He never got to sink his toes into his ancestral island's sand, knowing that our law truly recognised that as the land of him and his people. Looking back a quarter of a century now, it's almost impossible to imagine a counterfactual Australia. In other words, one where Eddie Mabo lost his case and there are no Aboriginal land rights in Australia. In other words, it's almost tempting to look at that victory as inevitable. I want to pause on that word inevitable because I've been hearing it a lot recently, and maybe you have too. This week, we learned that it's basically the chances of having a plebiscite to resolve the question of marriage equality are nil. It's not going to happen. But we've been told time and time and again that marriage equality is inevitable. We're also told that the last vestiges of discrimination against LGBTI people will melt away. And we're told at the same time that the shameful gap in life expectancy between Indigenous and non-Indigenous Australians will also inevitably melt away. And maybe it's true. Maybe these things inevitably will change. But I'm worried. I'm worried that that is a really dangerous game. I'm worried that if we accept the doctrine of inevitability, all of us as agents of social change, might be hugely disappointed. There are a couple of big problems with the inevitability worldview. The first is that you can only truly say something is inevitable after the event. However, there are lots of things that we're told are inevitable that never truly come to pass. I remember when I was a kid, I was told that the TV show Neighbours was so bad that it couldn't possibly last another season, and here I am, going grey, and it is still on the TV. We've been told that it is inevitable, we've been told for decades that it is inevitable that Australia will become a republic, and yet we're not. Here's a little interesting historical factoid. It was once so inevitable that New Zealand would become an Australian state that Walter Burley Griffin, the famous architect of Canberra, designed 8 avenues, all radiating from Capitol Hill, one of which was called Wellington Avenue. Of course, when the inevitability of New Zealand becoming an Australian state changed as if by the magician's pull back and revealed the inevitability that New Zealand would not become an Australian state, it was changed from Wellington Avenue to Canberra Avenue. The point of all of this is that inevitability is a cloak, and we shouldn't accept it at face value. I said that there are 2 problems with inevitability worldview. The second problem is that it encourages us to think in fatalistic terms. It encourages us to think that even if we remain passive, the inevitable day that we all hope for will come. But it's a really dangerous game. I've been involved in social change for many years now, and my observation is a simple one, and that is that if you do nothing, generally that produces no change. The status quo tends to grip really tightly. And so my core piece of advice to all of us as agents of social change is that we must reject the doctrine of inevitability. The only way to bring about change is to be patient, persistent, hardworking, to speak to people that don't necessarily share your worldview, to understand and communicate about the social problems of today, and to come up with really good solutions and to work your butts off trying to make those solutions a reality. There's a second related problem to inevitability, and I'm a human rights lawyer. I tend to emphasise the words human rights. I'm a human rights lawyer. But I've spent a lot of time working in public interest or human rights litigation. The only thing worse than losing a human rights case is the situation which unfortunately is all too frequent. It's known as the Pyrrhic victory. And I want to give you a good example of that. It's actually an example from environmental litigation. It's known as the Anvil Hill mine case, and it is probably the most important case that no one in this room has ever heard of. The case was known as the Anvil Hill mine, and it was a challenge to the establishment of that mine here in this state. And the challenge came up with a really novel argument, and the argument was heard by the wonderfully named Justice Payne. The argument was this: we know that in creating a mine, you're going to have all kinds of environmental impacts because you're going to be digging up coal, there'll be coal dust, there'll be all of this sort of stuff that happens. And that's something that the law has always recognised as something that's important to consider in determining whether or not to approve the mine. But the argument that this environmental group came up with, which was completely new, really just called to our common sense. And that they basically asked the question, why are we digging up all of this coal? Are we going to create some big coal mountain and then look at it and think, wow, that's a big black mountain of coal? No. The plan is to burn the thing. It's actually going to burn all of that coal. And that is going to have a really significant environmental impact. And what Justice Payne did was she said, yeah, we need to actually consider what will be the environmental impact, not just of having a mine, but of actually getting the coal out of the mine and burning it. And on that basis, she said, this mine should not go ahead. Immediately on saying that, you could hear the pops. And it wasn't the sound of Justice Payne banging her judicial gavel. It was the sound of champagne corks going off in celebration, because not only was this a significant decision in New South Wales, not only significant in Australia, it was significant worldwide. But as the environmental groups were celebrating this famous victory, the other side were marching to Macquarie Street and were already lobbying the state government to change the law. And they successfully changed the law specifically to overcome this decision. And so it is that we find ourselves in New South Wales with the Andal Hill coal mine. So we have to reject inevitability. Even when we win, we have to be really, really strong and be conscious that those wins may not necessarily be durable. I'm giving you, I realise, something of a tale of woe. I want to move now to a more positive element. So how do we actually bring about social change in a way that is durable and that will really, truly last? And I want to give a positive story. But the theory really is quite simple. There are three elements to lasting social change in a liberal democracy like Australia. The first, sadly, although in one sense happily for me as a lawyer, is you have to be prepared to fight. And in a country like Australia, fighting is generally not with our fists, but it is usually in the court. So you have to be prepared to take your legal rights to court, to have them recognised. The second strategy is that you have to make sure that our law and our policy truly reflects the society, the liberal democratic society that respects human rights that we all believe in. And the third is we have to be able to talk publicly and educate our fellow citizens about the importance of the changes that we're calling for. And we have to integrate each of those three strategies. So I want to move now to talk about, I think, the best example of that I've ever been a part of. So in my previous job, we had a client by the name of Graham Innes, and many of you will have come across him. We represented Graham in his personal capacity. And there are many things about Graham. One of the things about him is that he's blind. He's never let that stop him in any way, shape or form. Graham catches the train to and from work each day, as I'm sure many of you do as well. And the problem that he faced in Sydney, one of the world's major cities, was that we didn't have what are known as reliable, audible announcements. Now, that's just a fancy way of saying that when you get to your station, you need someone, if you're blind or you have a vision impairment, or like me, you're dyslexic, you need someone to be able to say, town hall, or central station, so that you know when to get off the train. And that's not just a matter of convenience. It's also actually really dangerous when you don't have that happen. We have another client who, as a result of getting off on the wrong station, ended up falling onto the train tracks with his guide dog. And he was injured. He could have been very, very badly injured. And I think one of the things that saved him from more horrific injury or death was that he was also one of Australia's most famous Paralympic skiers, so incredibly fit and very, very strong. But the problem is real, and no other major city in the world would stand for the sort of failure rate that we have. And the failure rate is huge. It was 20%. That means if you catch the train to and from work each day, then twice a week you'll find yourself on a train that doesn't have an audible announcement to tell you when to get off the train. So it's dangerous and a huge problem. And so Graham came to us and said, we need to sort this out. And we thought, well, this should be really easy to solve because, as I said, every other major country doesn't have this problem. And so we contacted Sydney Trains and we had various conversations, and they said to us, look, we realise your problem, but it's just too difficult to solve. Really sorry, but it ain't going to happen. And so we thought, wow, that's weird. Well, all right, well, we'll litigate. And so we decided to do just that. And Graham was right on board, and he took significant risk in doing so. So we took it to court. On the day before the hearing, I got a call from the lawyer on the other side. And he goes, Ed, I really like you. And I said, really? I really like you too. And he said, no, you got to understand, I'm going to do you a favour here. Your case is so bad that the court is going to do something that it almost never does, mate. I said, really, mate? What's that? And he said, the court is going to be so angry that it's not just going to make a costs order against Graham, which would be a tragedy. It's going to make a costs order against you personally. You are going to lose your house. I said, well, but I barely even own my house. That's like the bank losing its house. And he goes, no, it's not a joke. You're going to lose your house over this because your case is so bad. I said, but, mate, I think our case is actually really good. I think we might win. In fact, I think we will win. And he said, look, I'm just trying to help you, mate. I'm just trying to help you. Needless to say, we did win. And Graham was one of the most crucial reasons. It wasn't just our strong legal arguments. It was Graham being up there talking passionately and directly about the problem and the proposed solution. But it wasn't enough just to win that case. What we then had to do was we had to leverage that win by tweaking the law and policy in order to make sure that not just in Graham's case, not just the train that Graham would take, but every train in New South Wales would have proper announcements so that if you're blind or you had a vision impairment, you would know when to get on and off the train. And then the third element was education. We were told that it would cost $200 million to train the guards to say, town hall. I said, I reckon we can do it for half that. And in the end, the court said, we're just going to send the guards to the film and radio school. In fact, the guards really loved it. The first set of guards that went through, I don't know if any of you catch the Illawarra line, they're so into it that sometimes when you catch those trains, you'll hear them kind of go a little bit too far. So they won't just say, town hall. They'll say, forsooth, you have arrived at town hall. May your day be a merry one and a very happy one too. Which is not exactly what we were looking for, but it'll do. My point is that we've moved from a failure rate of 20%. We're not yet at world's best practice, but we're getting really, really close. And the way to do it was to integrate those three strategies. That's being ready to fight, being ready to advocate through the law and policy settings, and being ready to educate and speak publicly. And so that's what I want to leave with all of you. In order to be effective at bringing about social change, you need to be passionate advocates, and I'm sure you're all of that. You also need to have strong skills, and you need to have a good team around you so that you can be patient, persistent, and effective advocates for social change. Thank you very much.